Mm. Hi, everybody. This is Tamaya Robles. I am the owner of FixMyCreditNow850.com. I am a credit repair specialist, credit repair expert. I'm also the host of my podcast, Coast to Coast Credit, where we talk anything and everything of or pertaining to credit, whether it's directly or indirectly. So, like I stated to you guys before, I have a guest on. His name is Shiva Bhaskar. Back, sorry, I know we just talked about. Can you say your name, please? So I don't
Bhaskar,
mess
you're
it up.
right there. No worries.
Bhaskar. But yes, and he is a consumer credit attorney, and I told you guys that I've been doing this for so long, and you guys have, even though I'm getting deletions, there are plenty of opportunities for you guys to actually sue, and out of all the years I've been doing this, only one person has taken it that far. So maybe I felt like if I put someone on an attorney who specializes in this, maybe this will encourage you guys and just hear them out. And if you have questions, definitely leave a comment. If you want to reach out to him, if you feel you need his services, everything will be in the description below. But I'm going to step back and just, if you could just tell us a little bit about yourself, who you are, what you do, and share any cases or experiences with us.
Sure. Well, Tamaya, thanks for having me on, first of all. Definitely a topic I enjoy talking about. So, a little bit about me. I call myself a credit attorney or a consumer credit attorney, which means we help consumers who may have a legal issue involving their credit or a debt collection agency as well. We help them address that issues through use of the law. And there's a few ways that we do it. So, to give some quick overview, I did not start my legal career in this particular area. I graduated from law school at UCLA about 13 years back. For folks who remember the economy at that time, it was pretty bad. Took a little while to find a job. And when I did find a job, one of the things I found was I had some lates on my student loans and had run into a few credit issues, even though I had a good job. And as we know, bad credit can definitely hold you back. So, what all of that led to was me trying to figure out how to resolve that issues. And a number of years later, after working in a more corporate firm, I ended up starting Tier 1 Credit and Gopal Law Group. And basically, what we do is we examine credit reports as well as collections accounts and other accounts for inaccuracies and violations of the law. And when we can find them, then we bring a case and we might sue the credit reporting agencies, whether that's Experian or Equifax or TransUnion or many of the others, or we might sue a creditor for improperly investigating an account, or we'll go after a collections agency for violating the FDCPA. That's the Fair Debt Collection Practices Act for anyone who's not familiar. And the great thing about this is we can get relief for our clients, the consumer, so they might be able to get the account removed or the debt wiped out. They can also potentially get compensation. And it costs them nothing because our attorney's fees are paid by the credit agencies or the creditors or the collection agency. So I think it's sort of a win-win-win. It helps your credit, you might get some money, and it costs you nothing. So not everyone has a case, as we know, Tamaya, but whenever we can find one, um, it's great for the consumer, and that's what we focus on anytime we see a credit report or a collections account. Is there something illegal, or can we find something illegal which we could take legal action on?
Excellent. Thank you for that. So, I'm going to bring up a couple of scenarios
Please.
that I deal with, and just let me know if this is something that you help with and how. And I do have additional questions as well. So, the first thing is, a lot of times I'm a factual disputer, by the way. So anything that is reporting that goes against the FCRA and the consumer's rights, that's what I attack in my dispute letters. I teach that. I do YouTube videos on it all the time. But and that's how I get fast deletions. However, there's many times where I'm disputing and it's not coming off, and I know for a fact that this is a violation. I'm pointing it out, I'm showing it. Is that something that I would encourage my client to reach out to you about?
It sure is, yes. In a situation like that where you have spotted, I guess the top level thing, which you and I know already, but for the audience, the FCRA says that if a piece of information on the credit report is, it doesn't meet legal requirements, meaning basically it's inaccurate, it must either be corrected or the piece of information must be deleted. So that means the account needs to be removed if they can't verify it or it's inaccurate. So to your point, if something on there is inaccurate and they're not correcting it, then that could be the sort of thing that we need to look at, because this is inaccurate. If we can show in some way that it's harming the consumer, which usually you can, then then it's something to potentially sue on, and it might mean suing the credit agencies or suing the creditor or suing both. So yes, in those situations, I have found the reason why these things don't get corrected is because in some situations the credit agencies or the creditors are not worried about getting sued because, as you know, relative to all the inaccuracies out there, they don't really get sued that often, right?
Right.
They don't get
Mhm.
sued, but it's not that much compared to all the mistakes.
Mhm.
So they might do a cost benefit and be like, well, we're not too likely to get sued. But if that's you and your client dealing with it, then of course you're like, well, this is unfair. We should be able to do something. And yeah, that's precisely the sort of situation where we would get involved. Correct.
Okay. And so about how many rounds roughly should we go through before we actually refer the client over to you?
So this is one of those ones where you'll get different answers from different attorneys. So
Mhm.
I'll just say that this is my answer rather
Mhm.
than anyone else's, just to give you that disclaimer. I would say one at the most, two is fine. Now, the reason I said one to two is because if they have not properly investigated and either corrected or removed the information after one round of a proper factual dispute, then technically the legal violation is there. Sometimes we like having a second round because it shows the client put more effort and they were more harmed by it. Um, but you know, I don't particularly think, like, I know we have situations where there's four and five disputes about the same issue. I
Mhm.
mean, there's nothing stopping the client or the consumer or you or anyone else from doing it five times. I just, from where we sit, we're going to if there is a case, the case would exist after one dispute. So why not, get the lawsuit going and get this issue corrected so they can move forward with their life? That's how I look at it. Um, but it doesn't hurt sometimes to have a second dispute just to show you made that extra effort and they still aren't correcting it. But I personally don't think that more than two are necessary.
Now, in cases of bankruptcy, I actually can get bankruptcies removed. And what I've been teaching my clients and viewers is I say bankruptcies are public record, and what's going on is the bureaus are searching, they're searching for it. So the court system isn't voluntarily offering this information, the bureaus are looking for it, which means the bureaus are the ones that are reporting it wrong when we see it wrong,
Mhm.
reporting it accurately. So in a case like that, how, if we're disputing, because bankruptcies take a long time. In some cases, they take a long time for me to remove. But if we're on like round 4 with the credit bureau and we're only disputing the bankruptcies, is that something you can help with there?
Yes and no. So if the consumer indeed filed bankruptcy, um, if they did file bankruptcy, even if the dates or a few things are off, uh, that's not necessarily a case we would bring. Not saying that it's not good. I think in that situation, through credit repair, like you're addressing it, is the best way. The reason we probably wouldn't bring it is because if this goes to court, even if I can show a date here or a date there is wrong, it's difficult for me to really show unless it impacts when the account's being removed, which usually it doesn't do much because as of that date, the account is still there. We usually have a hard time in those cases showing damages, and the judge will turn around and say, well, it's sort of like identity theft, right? Well, is this your account or it's not your account? That's really what these come down to. So that sort of thing, I think the tactic that you're using is probably far better than a lawsuit is.
Okay.
But what I will say in bankruptcy that does work, what I encourage folks to do is if you can find, if we can, when, as you know, but for the education of the viewers, Tamaya, when a bankruptcy is filed, let's take a Chapter 7 because that's the easier one, right? They
Mhm.
have a discharge, which basically says these debts are discharged. They took whatever money or assets you had that were not exempt. They helped pay those debts, or usually nothing got paid. That is now discharge. Discharge is a fancy word of saying you don't owe the debt. You don't owe that obligation anymore.
Mhm.
A lot of folks, after they file bankruptcy, will still have some of those debts reporting a balance, number one, or there will still be late payments or charge off notations reporting after the bankruptcy was filed. And in any of those situations, uh, you've got a potential FCRA case if it's not corrected. Because once a bankruptcy was filed and it's moving forward, you can't keep reporting charge offs for 4 months after, or after it's
Mhm.
discharged, you can't keep reporting a balance. And
Mhm.
we see that regularly. So, one thing that I would encourage any of the viewers to do is I would think of removing the bankruptcy itself as one thing, which obviously you assist with. And the second part is they should get their discharge petition from the court. They can go on Pacer, the Pacer
Mhm.
website. They can get it, or they can just ask their attorney. That's the easier thing. Ask their attorney from the bankruptcy for their discharge. Compare the accounts on the discharge to what's on their credit report. If they don't know how to do it, they can reach out to us and we can look at it for them and see if any of those don't match. And if they don't, we can dispute it for them, or you can, whoever. And if it's not
Mhm.
corrected, we could sue. I see a lot of mistakes on the
Mhm.
accounts post bankruptcy. I encourage folks to look into that. Yeah.
Yes, I agree with that wholeheartedly. Wholeheartedly. I have a client now. It's a husband and wife, and the wife has a bankruptcy reporting on only two out of the three, and they are discharged. But she has nothing, no collections, no charge offs under the bankruptcy showing. Her husband, she messed up his credit. She actually listens all the time, so she knows I'm talking about it. But she's okay with it. But her husband, she has two bankruptcies that she put on her husband, but all the collections that are under the bankruptcy are wrong. Like their discharge is a discharge bankruptcy, but everything is just wrong and chaotic, and but it's slowly coming off. But it's exactly what you're saying. So that's good to know. You just let me in on something, because usually when I handle the bankruptcies, I go to Pacer and I pull up the information on their behalf. But that's cool because I have a lot of DIYers that like to do it themselves. So that's good to know.
Right. Yeah, Tamaya, that's exactly right. I recommend anybody. Um, I recommend anybody. The number one thing they should probably do after bankruptcy, not immediately necessarily, let's say within 60 days, because we know, as you and I know, it takes time to update. Within 60 days, they should be going on Pacer, pulling that, comparing the accounts, and seeing if there's anything that is still reporting a balance or there's still a balance. Because after that, if they're in a state like California, they might automatically have a case against that creditor, because
Mhm.
we have state law. But in most states, if they dispute it and it doesn't get corrected, they've got a case. And my experience has been probably 6 out of 10 times that you send in a dispute about the bankruptcy and say, hey, this was discharged. It should be saying zero balance, not reporting that I owe $3,000.
Mhm.
Maya, 7 times out of 10, they're still not correcting it. So
Mhm.
most folks
Okay.
are going to see this and it's not going to get corrected, and then they can sue and maybe get some money
Okay.
back. The way I think of it is you paid a lawyer in most cases for the bankruptcy. Why not try to get some of that money back through a lawsuit, covered part of your legal
Mhm.
costs?
So should they pick up where they left off with their own attorney, or can you still help them in that
Good
situation?
question. So they're welcome to find an attorney in their state, of course. I mean, I would never tell anyone not to do it, or if you know another lawyer and you recommend them, that's great. What we kind of do focus on, though, is we've got a network of attorneys, right? So, uh, like, let me think of an example. Like, let's say tomorrow you have someone in Texas. Okay,
Mhm.
that's one example. We could pick a smaller state. Okay, we could say Louisiana because I've got some cases over there, right over the border.
Mhm.
If
Mhm.
you have someone in Louisiana, they can certainly look for a local attorney. I think one good place to look for them is Avo.com. Yelp, as we know, it's not just good for restaurants; it can be good for
Mhm.
lawyers too.
Yes.
But if you want to save the time of trying to find someone and figure out if they're good, or calling lawyers who are like, no, I don't do that because it's a very specific area of law, as we know. We work with a network of attorneys around the country, including some national law firms. I'm always happy if you have someone who's in a different state. Um, outside of maybe the Dakotas and a couple other states, we have people who can take these in almost any state. So we'd be happy to look at their file. We can take it in, and then we can, place them with the proper attorney in their state who can move the case forward. Or it might be a lawyer in a different state, but they've got local counsel that'll file the case. So, point being, from our end, we've got clients I have cases right now in, huge states like obviously California, where I am, New York, Texas, but we've also got, smaller cases. I just had one come in from Nebraska, other places. Point being, yeah, the case can be brought anywhere. So if folks want to look for an attorney online or ask you, of course they can do that, or they can reach out to us and we're happy to try to place it with the right person.
So anybody that comes to me, I'm going to naturally refer them over to you. But what I was saying is that the attorney that they use to file bankruptcy, unless they file on their own, because I do have clients that file bankruptcy on their own. But when it comes to what the negative still showing on their report, do they go back to the same attorney they filed with? Because to me, it seems like just because they handle bankruptcies doesn't mean you're more of a specialist in that area.
You're exactly right.
Okay.
Of all the bankruptcy attorneys that I know personally, I can only think of, yes, dozens of them, maybe hundreds. I can only think off the top of my head of two firms that not only filed a bankruptcy, but they bring these cases where there's a mistake afterwards. I can only think of two. Honestly, I'm surprised more of them don't do it, because a lot of them would make a lot more money with it, but a lot of them prefer not to get involved, and they refer it to firms like ours or other firms to do it, because they're like, no, I want to focus on it. So I'd say they could go ask the attorney, but in most situations, unless they're dealing with one of these two attorneys I can think of, most times that attorney's not going to do it. They may have a referral, or they might just say, hey, go look for someone. But to your point, anytime that we see these issues, we would take it. Yeah. Most bankruptcy lawyers don't do this because, as we know, bankruptcy versus this is two different models, right? Bankruptcy, you go file the case. It's not as much hands-on. That's not a knock on bankruptcy attorneys, by the way. It's just the nature of it. Versus FCRA is more hands-on. So a lot of them are not really built to deal with these cases, is my experience.
Okay. Now, I was always curious as to why some of my clients just refuse to move forward with litigation. And I think a lot of it is fear. And in most cases, they don't believe, right? So they already don't believe in credit repair, most of my clients, until they meet me. And then they're like, oh my gosh, I didn't know. But when it comes to the legal system, they definitely don't believe. They don't feel confident enough that they could win or it's worth their time. What would you say to my current clients and my potential clients who believe that?
Sure. Well, I understand where they're coming from, because people have seen situations where the legal system does not work or it takes too long. And I'm talking about civil cases here, right? Someone gets hurt in a car accident, it takes years to get a settlement, or something happens at work with their employer and they're not being treated fairly, but they don't feel like they have legal recourse. So I definitely understand, where they're coming from. And I'd say a few things. The first one is, what do you have to lose? And that might just sound like a smart ass remark, but let me get into it a little more. What I'm really trying to say is this. If you decide to pursue a case under the Fair Credit Reporting Act or the Fair Debt Collection Practices Act, you're never going to pay me or any other attorney money for it. Okay? You are never going to write us a check or have to go in PayPal or Cash App or anywhere else and pay us. And the reason is because the law says that if there's a case, and meaning that it gets resolved either at trial, which it very rarely does, or at settlement, the reasonable attorney's fees of the attorney for the consumer has to be paid by the defendant. Defendant is the credit agencies or the credit card company or the collection agency. So our fees are paid. Okay. So you're never going into pocket and paying us for anything. That's number one. Now they might say, the second question that comes up is, well, what if you guys lose the case? Well, I would say two things. Number one is, we review the case carefully before, as you know, to see what we have. If we don't think that this case is realistic to win, we're not going to take the case. I mean, as Tamaya knows, if she reaches out and not to do it, but if she's like, hey, do you think this is the case? And we don't think it is. We'd say, no, it's not. Like you would do credit repair, and that's a better approach. We're not going to take it. And the reason is because we have to pay the filing fees. We have to pay the court costs. We have to pay our paralegal to write up the case or write it up ourselves. We won't incur all those expenses if we don't think we can win. So I'd say you have an additional level of screening against losing because, A, if we lose, you never pay us anything. We don't come back to you and say, oh, pay us the filing fees, pay us this. If we lose, then that means we brought a bad case. We shouldn't have taken your case, and we're not going to charge you a dime. Now, if we get a settlement, then of course our fees get paid and you can get paid too. So I'd say you have nothing to lose, number one. Number two, in many situations, this is the only way to get it resolved. You and I both have seen identity theft cases and you dispute it 2 and 3 and 4 times. And it really is identity theft, but it doesn't get cleared. There are plenty of situations where people end up coming to a lawyer because that's the only way that this can get resolved. They've tried doing it on their own. Maybe they've tried credit repair. Some of them worked with a great credit repair company, but the truth is the only thing that would resolve this is litigation. So I'd say that. And the other thing I'd say besides this may be your only route and what do you have to lose is you can get paid. I mean, this is the ultimate paper delete. They're paying you to delete your accounts, okay? And I had to give credit. I have another friend, John, who's an attorney in Alabama. He came up with that line. He's like, this is the ultimate paper delete because they're paying you to delete your account as part of a settlement. So, I mean, you know, if any of you all who are watching this, you don't want the money for yourself, you know, give it to a friend or a relative who needs it, or give it to a charity, whatever it is. Give it to, you know, give it to the person who's helping you, whoever. But you can get paid to get this deleted from your credit. I mean, I don't really know what else better we can offer than that. You know, you're getting the account correct, you're getting the issue corrected. It's not costing you out of pocket, and depending on the case, you're getting paid. Now, I will answer the objection of why people don't want to do it. People don't like going to court. So I won't say this is true 100% of the time. Most in federal court, which as we know is where most of this is, you're not showing up with your lawyer in court on day one. It's not like a criminal proceeding where everyone's standing up and do you plead guilty, do you not? Most civil cases, the plaintiff is not showing up on day one. What you might need to do at some point is a deposition where the lawyer for the opposing side asks questions, as we know, but your lawyer is there. They'll object if anything's wrong. And in a deposition, what I say, all you do is you tell the truth. Okay. You explain what happened, what you know, what you understand. Your lawyer will guide you on it. And that's it. And the other attorney can ask you questions, but they're limited in what they can ask, and they have to follow the court rules of the court. If they misbehave in a deposition, they can get in a lot of trouble with the court. So really, you have nothing to lose. Just like tell the truth, tell your story, and you can get relief and you can get this corrected with less hassles, I would say, versus maybe trying to do it yourself or whatever.
And so with that being said, roughly how much can someone typically get paid? And from my research, I heard it was 1,000. I read that it was 1,000 per negative account. Is it per month or? And then I read another attorney say no, it's actually 4,000. So roughly on average, how much can they get back?
So yes, with the $1,000 number, which you mentioned first, we have 2 types of damages. I guess not to get into the mumbo jumbo of it, but we got statutory damages, which means if there's a mistake on the credit report, which is worth a lawsuit, it harmed the client, but you can't demonstrate much other harm. Like you can't show you were denied for a mortgage or an apartment or something or a credit card because of it, then okay, it would typically be $1,000 plus your lawyer's fees, which are a lot more than $1,000, but thankfully you're not paying for a penny of it, right? So that's 1,000. Then you have actual damages, and I'm talking about FCRA, meaning credit reporting here. That is where you were denied for credit, you lost opportunities, maybe you were denied for a job because of your background check and the credit. Those damages can be massive. Those damages can go into the hundreds of thousands, or in very rare cases, even millions of dollars. Those can be huge. So I'll give. And I can't give the exact number because the settlement's confidential, unfortunately. I had a gentleman who was trying to buy a home for his family. He lived in New Jersey. Someone opened a Bank of America in his name. It was not his account. He filed police reports. He did He did
Mhm.
everything that, like, say, Tamaya or myself or anyone else would tell you to do. Nothing
Mhm.
worked. Then he found our firm, came to us. I referred it to a colleague in New Jersey who does nothing but these cases all around the East Coast. They sued, and we had each credit agency as well as the creditor um, paying him in the tens of thousands of dollars in damages because
Wow.
this was in 2021. If
Mhm.
you all remember the housing market, it was just going up, up, up. And
Mhm.
he lost out on the opportunity to buy multiple houses
Wow.
with his credit. And that's
Mhm.
worth a lot because it would have sold for 400,000. Now it's 500. I mean, so point
Mhm.
being, you really get harmed by it as you can do it. But that's the credit reporting. Now, debt collection, where they're calling you inappropriately or they don't mark your debt disputed, that's
Mhm.
$1,000 in most
Mhm.
cases. That's 1,000.
Mhm.
And I
Mhm.
should note that the law says up to $1,000.
Up
So
to
there are
okay.
cases where it could be $300 or $400, but
Mhm.
most times we're able to get the full 1,000. Most
Okay.
times you can.
Okay. Okay. Well, I would love to sit here and ask 100 more questions to you, but I know I'm sure you got to run. But I appreciate you coming out here for sure. And I'm offering an open invitation. Feel free to come back anytime you want. I know you're going to get a lot of responses from this video. So, anything you want to say before we close out?
Well, again, thank you for having me. I'm glad to have anytime there's a chance to share with folks what this is. I appreciate that. And I mean, there's a very important question to Maya raised, which is the number one issue more people don't bring cases, which is being afraid. Uh, not to be the motivational speaker, but just to end on that note, I think anything in life, we know that once we get beyond the fear of it, that's where the really good stuff happens, right?
Mhm.
Whether it's business, whether it's personal relationship, whether it's love, and certainly whether it's legal. Once you get beyond the fear of it, do that. And consider something else. These credit agencies and these collectors that are violating your rights and harming you, they're not afraid. They're
Mhm.
continuing to violate your rights every day. They don't seem to lose sleep. They're making millions or billions of dollars. So
Mhm.
aren't they the ones that should be afraid because they're the ones that are harming you? But instead, we're afraid because we don't know what it involves because we're not in the court system day to day, maybe the way that I am. And I understand where the fear comes from. But what I would say is give yourself a chance because I've seen a lot of people suffer with things that a lawsuit would resolve. I've seen people
Mhm.
suffer with it for months or years,
Mhm.
including this gentleman whose story I just shared.
Yeah.
And they lose out on opportunities and life happens and passes by and you're suffering because of it. So why not stop suffering and start living? And if we can help
Mhm.
with that through the legal process, we'd be honored to.
Excellent, excellent. I agree wholeheartedly, and I'm so glad we're on the same page. And this also proves that, like in this industry, credit repair, as you know, specialists are considered like shady and shisty, and I'm not that one. So I was like, let me get an attorney on here to reinforce what I'm saying. But I truly appreciate it. Thank you so much for your time. Again, if you guys want to reach out to him, I'm going to encourage that you do. All his information is in the link below. But in the meantime, I wish you guys the best of luck on your credit journey. And again, thank you for joining me today.
Thank you, Tamai. I appreciate being here.